Narrator, off. Daun tennis ducks. today's No Mamas Award goes to this pinche haircut. The double muskrat pink rat tail situation. What in the possum is happening here? Let's play a little game called Austin or Portland. Barista or what the fuck? Que pinche perro. The ball fade, front mullet, business in the front, tacuache in the back. Edgars of all shapes and forms. And today's No Mamas Award goes to this pinche haircut. The double muskrat pink rat tail situation. What in the possum is happening here? Let's play a little game called Austin or Portland. Barista or what the fuck? Que pinche perro. The ball fade, front mullet, business in the front, tacuache in the back.
Can I get a tally of brands in the comments telling me how many companies have changed their logos to something about pride? I don't care all that much about it. That kind of representation doesn't allure me very much, but I am very curious about, how far we've fallen in terms of corporate pride events. So let me know. Can I get a tally of brands in the comments telling me how many companies have changed their logos to something about pride? I don't care all that much about it. That kind of representation doesn't allure me very much, but I am very...
Next time you're creating something healthy, refreshing, and low carb, try this cucumber broccoli salad. It's got so much going on, and it's so good. Just slice up some Persian cucumber.
Tornado iceberg. Before I start, I just want to say I'm not a meteorologist, but I am going to be talking about these topics just briefly from what I understand, and I'm going to try to do so respectfully because I know a lot of people have been affected by tornadoes recently. Starting off with dead man walking. So this is a phenomenon where people see these multiple vortex tornadoes that sometimes look eerily similar to a person walking. These things have individual vortexes that appear as legs or arms, and the most famous one was the Gerald tornado that was an F5 that hit Gerald, Texas in 1997. It was very strange because if you look at the footage of this one, it doesn't hardly move. It just sits in a small area and just grinds it to dust. Ghost tornado, this is just a reference to tornadoes being kind of invisible. There's these types of tornadoes that are nearly invisible because there's not enough condensation to make the funnel seen, and this can sometimes be very dangerous because people might not act or get to safety or even realize there's a tornado there. The 2011 super outbreak. So this was one of the deadliest tornado outbreaks ever recorded. In a span of only 4 days, there was 368 tornadoes confirmed by the National Weather Service, and several of them were high-intensity EF5 tornadoes that went across multiple states. EF5 sonic booms. So this was a widespread rumor that was specifically about the Smithfield EF5 tornado in 2011, where people thought they were hearing sonic booms because of how fast the tornado was moving. This Smithfield tornado was very devastating in rural areas like Mississippi and Alabama, and the locals were saying that they were hearing sonic booms coming directly from the tornado. However, meteorologists say that it's far more likely that they were hearing like bangs and explosions of different debris and stuff blowing up the tornado, but you never know. The 1932 Great Kanto Fire tornado. So this was a natural disaster that took place after the 1923 Great Kanto earthquake that struck the Kanto plain on the main Japanese island of Honshu. This earthquake was an 8.2 magnitude earthquake that started fires, and then these fires were further fueled with wind that formed into these rapidly moving fire whirls or fire tornadoes that resulted in significant loss of life. In one instance, there was 40,000 people that were evacuated, and they were gathered in an open space where they were then all wiped out by a fire tornado. The Blackwell Supernatural F5. So this was an F5 tornado that struck Blackwell, Oklahoma in 1955. And for one, it was really strange because it went in almost a completely straight path. But what was really weird is that it glowed blue. And I'm not just talking about the lightning occasionally flashing and looking blue, but rather eyewitnesses were saying that it had a constant blue glow that was at the top of the funnel, and some were even comparing it to an arc from a welder. Not only that, but people were also saying there was these balls of light that were surrounding and rotating around the tornado, and some theorized that all of this light and the glowing could be ball lightning, but it's a really weird event, and maybe it was like some sort of continuous intercloud lightning. It's still a mystery today. The rolling fork lights. So This was a reference to what people think is a car that got picked up in a tornado. There was this storm chaser that was filming this large tornado in Rolling Fork, Mississippi in 2023 when he captured what looked like a car getting pulled into the rotation and then taken way up into the sky. Nobody knows for sure what was captured in this video or if this actually was a vehicle or if there were people inside if it was a vehicle. But whatever it was, does look like a car's headlights that went a couple hundred feet into the air and was circling this massive tornado. But still, after looking into it further, I can't find any information on if anybody figured out what it was. The Joplin butterfly people. So the Joplin tornado was another terrible tornado in 2011. It was the single most costly tornado in recent history, with damage totaling $37 billion in damages. The reason why this tornado was so bad is because it went directly through the middle of town, which was probably the worst path it could have taken, and there was 158 fatalities and over 1,000 injuries. What's really interesting is people, particularly children, who didn't even know each other, all around town started to recall seeing these butterfly humanoids that protected them from falling debris or lifted them up and pushed things from hitting them right before they got injured. And if this is real, to me as a Christian, this sounds a lot like some sort of guardian angel or divine protection from God. But others like to say this is just people coping and it's kind of like mass hysteria after a terrible event. Anyways, tornadoes are terrible and I hope I didn't cause distress, but it is really interesting all the strange phenomenon surrounding tornadoes. It seems like this year we have had an insane amount of tornadoes, at least in the area where I live. But seriously, stay safe out there, guys. Thank you guys for watching, and I will see you in the next one. Bye. Tornado iceberg.
That is super. I'm sorry, sir, but you have 10 seconds left to live. It's best to say your goodbyes now.
There's just one last thing I want to say.
I'm sorry, sir, but you have 10 seconds left to live. It's best to say your goodbyes now.
We also have Todd Wedlow on the calendar.
Oh, yeah. I'm
Take
sorry.
out a motion to revoke bond. He has 3
Next
cases.
page. Yeah.
Good morning.
Also,
Good morning, y'all.
Good morning.
Renee Williams as well, Your Honor.
Okay. All right. I'm confused. So, Mr. Wedlow, there's a motion to revoke bond. Why isn't he in court?
And Your Honor, I spoke with counsel this morning, and I informed him that I would ask for him to appear in person because it was a motion to revoke bond.
And it should have said that on the notice.
Judge, my understanding is Mr. Wedlow, I did speak to him about that typically we do motions to revoke bond.
Not typically,
But he informed
all
me.
the time.
Excuse me, ma'am. You didn't request that. And remember the last time we had spoken? I just didn't know. I had no idea. I'm not to disrespect the court.
And so,
So, Mr. Lynch, Mr. Wedlow, I always say if it's a motion to revoke bond, you're coming in person. Also, the notice says that if it's a motion to revoke bond, it's in person in the courtroom. Also, Mr. Lynch, I'm gonna need you to say it with your chest. We don't just typically do it in court for a motion to revoke bond. We do it all the time. Motion to revoke bond, they're gonna appear in person in the courtroom. Now, the last time we had one and you said, well, if they're appearing in person, I want all the witnesses in person. And I said, bet, we can do that, no problem, all day. But if I'm gonna do a motion to revoke bond, I wanna be able to lay my eyes on the people. I wanna know that if I grant them.
That's what you say?
Mr. Wedlow, you need to mute your microphone while the judge is talking.
You can.
That's probably what the problem is. He's talking while somebody else is talking. He's not listening to the part that said, you're supposed to be in the courtroom when I do a motion to revoke bond. Because people talk too much. They talking while I'm talking, or somebody else is talking, trying to give them instructions. They're not listening because they talk about what they want to think about.
Excuse me, ma'am. I'm so sorry.
Mr. Wedlow,
Now it's not the time. You don't want this talk. Now it's not the time. Because if you wanted to say something to me, you would have followed the instructions that I gave you, which was to be in court. All right, now what were you saying, Ms. Ponder, about this motion to revoke bond?
Your Honor, the state is still requesting that Mr. Wedlow appears in person. We have several cases on the calendar, but the state is making that request.
Now, Mr. Lynch, may I hear from you?
Judge, we would consent to have this, or we would to have this continue to a further date and have
I bet you would, other than me sending out a bench warrant and having County Uber pick up Mr. Wedlow. I'm sure you would consent to that.
Judge, so I understand the court
has two cases that have violent content. He has battery cases in 2024, and he has another case of battery in that's a 2024 case. And so he's already got two cases pending. If his bond conditions say what I think they say, then it is more likely than not he has violated his bond conditions, just on the fact that he picked up another case after the first case. So, Mr. Wedlow, is he in the state of Georgia?
Yes, Judge.
Where is he?
I believe he's a resident of Clayton County, Judge.
Well, he needs to get his resident self into court within the next 20 minutes before I have to send County Uber to go get him. And I am telling you, it will not be a 5-star ride.
Yes, ma'am.
Thank you. Wedlow, who seems to still be on the screen, he must have really good internet, because if he was making his way to the courthouse, then he probably would have logged off by now. And Williams.
No, ma'am. No, ma'am. Actually, I have no way, and I'm trying to figure out a way, ma'am.
Your Honor, may the state would like to share its screen with the court momentarily for a moment. The state has a copy of Mr. Wedlow's rule nightside that says that he is to be in court today. If the court would like to see.
I don't have to see it, Mr. Tipton. I know what my order says.
Yes.
I'm clear that he's supposed to be in court. It seems Mr. Wedlow is the only one who is clueless about the fact that he should be here as opposed to on the screen, because I know what my order says. I'm clear on it.
I'm trying, ma'am. I'm on my way. Any way possible.
Your Honor, if Mr. Wedlow does not appear in time by the close of calendar, state would request that the court revoke his bond based on failure to appear in person during the motion to revoke bond.
That's on the table.
The defense would, well, Judge.
Yes, Mr. Lynch.
So, my understanding is that Mr. Wedlow's trying his best to get up. So
that's your understanding, Mr. Lynch? Because if he was trying his best, he'd have been on a bus this morning at 6 o'clock, or walking. I've had people walk to court, and I have a lot of respect for that. Or one of the 3 to 5 people I saw with the Wedlow last name could have given him a ride.
Well, Judge, they couldn't have, based on the orders of the court.
I'm trying to get an Uber now. Excuse me. I'm sorry. I'm trying to get an Uber now. I can't walk that far in that short of a time. I'm trying to get an Uber now.
Okay.
Please give me a second. Please. I'm not trying to disrespect the court in any way.
Okay.
I'm on my way. Thank you.
We're still waiting on,
Gilmore.
yes, I got you, Mr. Gilmore. Can I
Okay.
put my calendar?
Okay. Thank you. Okay.
So we're
And
waiting.
I'm on the way now.
Mr. Wedlow, what did I tell you?
I'm so sorry, ma'am, if I disrespect.
I need you to stop interrupting me. Mr. Lynch, we have any idea how long Mr. Wedlow is going to take to get to the courthouse in Clayton County when he lives in Clayton County?
He indicated it would be about 11 minutes
From,
from now.
so, is this Wedlow? We ready?
Judge, we are ready, although I do have to put something on the record.
Go ahead.
So, Judge, Mr. Wedlow is here present in court.
Good.
But we would, though, object to any virtual testify of the alleged victim, testimony in the alleged victims. I believe that the
Okay, y'all waived that when he failed to show up as announced, and the court has had to wait for him to get here.
Okay.
Y'all were willing to go for it as long as I would let him stay at home, but now because I made him come in, which was what the notice says, now you want to bring that, no, well, we don't want any virtual testimony. I'm not playing games, Mr. Lynch. You can put it on the record, and then if you want to appeal it, you go ahead and do that, but we're not doing this.
And I understand, Judge, but for the record, I would just say that I didn't consent to any witnesses testifying virtually and I didn't expect him to appear virtually. That certainly wasn't my instruction. And so that is just, we do object to that for the record, Judge.
Okay, let's go on. All right. State of Georgia versus Taj Brandon Wedlow.
The first witness, Your Honor, that the state will call, we'll just ask for if counsel and Mr. Wedlow can go to the table so that our witness can stand at the podium to speak. Thank you. Officer Freeman.
All right, Officer Freeman, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
And do you recall when you responded to this location, what was it for?
It was for a domestic dispute.
Okay, did you have any contact with any individuals?
Yes, I did.
Okay, and who did you have contact with?
I had contact with Eric Wedlow, a Taj Wedlow, and a Cedric Wedlow.
Okay, so you had contact with Eric Wedlow, Taj Wedlow, and also Cedric Wedlow at this location?
Yes.
Okay, and did you have an opportunity to speak with, and what did you learn during your course of investigation after speaking with Mr. Eric Wedlow?
Well, Eric Wedlow told me that Taj had attacked him and punched him in the face multiple times. And all started because Taj was trying to be in his business while he was on the phone.
And at this particular incident, did you observe or notice any type of marks on Mr. Eric Wedlow?
No, I did not.
Okay. And did you have an opportunity to speak to Mr. Taj Wedlow?
I did.
Okay. And what did you learn from Mr. Taj Wedlow?
Taj explained to me that Eric was talking about him on the phone, and so he got upset and wanted to confront him about the situation. And I think he said also that Mr. Eric had a broom in his hand and tried to use it defensively against him.
Did you arrest anyone on that day?
Yes.
Okay, who did you arrest on that day?
Taj Wedlow.
Okay, and why did you arrest Mr. Taj? What did you arrest Mr. Taj Wedlow for?
I arrested Taj Wedlow for simple battery, family violence.
Okay, and how did you come up with that decision?
So based on the testimony that he gave to me and from the testimony that Eric gave as well, Taj admitted to punching Mr. Eric Wedlow. He also tried to tell me that he told me that Eric pointed the think it was a broom, I think. Point the broom at him, he never hit him, but he also told my partner on scene that Eric did hit him. So he basically like he told me a different story than what he told my partner on scene. Also, Sergeant Wetlow is there as well to testify as well.
Okay. No further questions from this witness. Thank you, Your Honor.
Cross-examination, Mr. Lynch.
I'm sorry, I just wanted to make sure I got the date correct. Officer, what date were you just referring to when this allegation allegedly happened?
I think it was in May. I'm not sure that day. May, I think.
No further questions at this time.
All right. And let's call the next witness.
Your Honor, the state will call Mr. Eric Wetlow.
Mr. Wedlow, raise your right hand for me. Mr. Eric Wedlow.
Right here. Can you see me?
All right.
Hello?
I see you.
Okay.
Well, I did
Okay.
see you. Yeah, there you go. Raise your right hand. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
Okay, you can put your hand down. If you can
Yes.
reposition yourself to
Okay.
somewhere where your Wi-Fi will pick up better, that would be good too.
Yeah, that's what I thought I did when I moved in the kitchen, but let me try back here.
Okay. Do you recall who called the police?
I did.
Okay, and why did you call the police, sir?
I was assaulted by my nephew.
Okay. And did you provide that
Taj.
same... I'm sorry, and what is your nephew's name?
Taj Wetlow.
Okay. And did you provide that when you say assaulted, what exactly did he do?
He punched me in the face.
Okay. And so was that information provided to law enforcement on that day?
Yes.
No further questions from this witness, Your Honor.
All right. Cross-examination, Mr. Lynch.
None at this time, Judge.
All right. Mr. Eric Wedlow, just hold your excuse at this time, but don't go anywhere.
Your Honor, the state will call Officer Freeman back to the stand.
Officer Freeman, you're still under oath. Your witness, Ms. Ponder.
Thank you. Officer Freeman, I want to bring you to the incident date, December the 26th, 2024. Were you in fact employed with the Clayton County Police Department on this day?
Yes.
And why did you respond to this incident location?
I got a call about somebody in the backyard of Eric Wetlow's home. He believed it was his nephew, Taj, who was not supposed to be there.
Okay. And when you arrived on scene, did you make contact with anyone?
Did
Okay. Who did you make contact with?
when I first arrived on scene, I made contact with Eric Wetlow.
Okay. And what happened?
He explained to me that he believed Taj was in his backyard, in his shack, I think it was, or his trailer, whatever. And so I went back there and I, in fact, did locate Taj in the back of the home. Also, Eric did have paperwork showing that Taj is not supposed to be anywhere around him or on his premises, according to the family violence order.
Okay. And did you make contact? You stated you did make contact with Mr. Taj Wetlow?
Yeah,
Okay. And did you place him under arrest?
I did.
Okay. And did you and what did you charge him with?
Violation of a family violence order. He also
Okay.
about the order as well.
Okay. No additional questions from this witness, Your Honor.
Cross-examination.
On that incident date, officer, there was no evidence that Mr. Wedlow, Mr. Taj Wedlow, actually made contact with either the home residents. Is that correct?
I mean, that's how he got in his backyard. He got to be on his property.
My question is, the allegation was that he was in the shed in the backyard, not that he had made contact or there was any kind of violent incident. That's fair to say. Okay. And were you wearing a body cam during your investigation?
I was.
Okay. Do you know whether that body cam has been preserved?
Yes, it has.
And as far as the last incident date that we spoke about, you were wearing body cam during that incident date as well?
Yes.
You know whether that's been preserved?
It was.
No additional questions at this time.
Anything else from the state?
Nothing from the state, Your Honor. I would just ask if this witness can be excused.
Yeah. Officer Freeman, you're excused. Please be safe. Thank you.
At this time, Your Honor, the state will call Mr. Eric Wetlow again.
All right. Mr. Eric Wedlow, you're still under oath, sir.
All right, Mr.
Okay.
Wetlow, I just want to bring your attention to December the 26th, 2024. Did you call the police on this particular day?
Yes.
Okay. And why did you call the police on this particular day?
Because I went to my car and I heard my nephew singing in my grandpa's camper. It's an old camper my grandpa used to have. It's on the property. It's right behind the house. And then I went back in the house. I didn't confront him. I went back in the house, called the police, and called 911. Told him to come. He's not supposed to be here. And they showed up, and I directed officers where he was at. They went back there, knocked on the camper, and asked was he in there. He came out. And that's when they arrested him. I showed him the paperwork that he's not supposed to be here. He was trespassed. He violated the PTO I had, protection order against him. He had violated that, and he should be, arrested.
Okay. No further questions, Mr. Eric Wetlow. Thank you.
All right. Cross-examination?
None at this time, Your Honor.
All right. Next witness?
Your Honor, the state rests at this time.
Mr. Lynch?
Your Honor, I would ask that you consider not revoking Mr. Wedlow's bond at this time. Mr. Wedlow is 28 years old. I know that he is actively seeking employment, and as far as the allegations that were testified to today, he is presumed innocent until proven guilty beyond a reasonable doubt, and he would request that his case go on the next trial calendar so that he can have the right to confront his accusers. Mr. Wedlow, as you saw today, presented himself to court voluntarily, and so that should indicate to the court that he is not running away from this. He wants to get this resolved. Judge, he just looks forward to his day in court where he can contest these charges and have all his rights to confront the witnesses against him and to testify if he so chooses to, Judge. Obviously, there's two sides to every story. Mr. Wedlow exercises his right to remain silent today. However, he does look forward to the trial when he will have an opportunity to his attorney to try to tell that story, Judge. I don't believe that Mr. Wedlow has a history of violent charges that I'm aware of. I think he may have a burglary. We consider that violent, but I don't think there's lengthy history of violent offenses. And so, Judge, we would ask that you allow him to remain on bond until at such time as we can get these cases tried in front of the jury.
And Your Honor, if I could be heard, I know that counsel...
Hold on just a second. 1 second. I'll be right back. All right. Ms. Ponder?
Your Honor, the state would just like to provide the court with some information based upon counsel's statement regarding the defendant's criminal history. The defendant was under first offender for burglary in 2019, in which he was on probation for 4 years. He just got off probation. He has a criminal trespass conviction. He has now 4 open cases, Your Honor. He just got out of jail this weekend. He was charged with disorderly conduct, and that incident happened on May the 10th, 2025.
All right. You brought up his record. You opened that door, Mr. Lynch.
I didn't, and I understand what you're saying, Judge. I didn't want to object, but I understand she referenced the open cases in a disorderly conduct case and the burglary that I mentioned. So I understand that I didn't hear a history of violent offenses.
Okay, here's the thing. Mr. Wedlow is entitled to be innocent until proven guilty. He has not been proven guilty of the underlying offenses. But what the testimony of the officer and of Mr. Eric Wedlow shows is that he has violated his bond condition. The bond conditions say not to go on the premises on them. The bond conditions say not to have contact with Eric or Cedric. He's had contact. The bond conditions say not to pick up additional charges. He's done that. And not just once, but more than once. And so with that being said, while he is innocent of the underlying charges, he has committed bond violations. And with respect to that, not to mention you argued, and you have to be very careful with your words, because you argued that he voluntarily came into court. Well, did he though? Because really, I had to tell him that if he didn't come in, he was going to be picked up by the sheriffs through county Uber. So my notice said voluntarily come in, or not even voluntary. I'm compelling you to come in person in court. I'm just be honest. I'm telling you, come in court, and he did not do that. And then I had to wait for him to get here for us to have the hearing. And then once we get here, that we're shifting and we're changing again. I've heard enough based on the testimony that's been presented, where yes, he is innocent of the underlying charges, but did he violate his bond conditions? Yes. Did he violate his bond conditions and present a picture sufficient for the court to find that it is necessary to revoke his bond? Yes. And so at this time, based on the evidence and testimony presented, Mr. Wedlow's bond will be revoked. He'll be taken into custody until such time as his cases are resolved.
Judge, what would, if it's possible at this point,
He's an active inmate, and I believe he's already on the next available trial calendar. So as an active inmate, he'll go to the top of the list anyway.
Thank you, Judge.
All right. All right.
Am I dismissed as his father?
Yes. Anybody connected to the Wedlow case, you're free to go at this time.
Thank you, Your Honor.
Thank you.
All right. Next is
I told you to sit your ass down. I told you to sit your ass down.
Mr. Wedlow. I'm hearing you say all of that, sir. You are cussing on him. Please, before I have to put you in contempt, and that's 10 days, please just get off the call before you start with the praises. All right? Lord, is nobody...
I'm sorry, I thought I had clicked off.
This has been a very challenging day. All right, let's go back to our calendar.
What are we doing on this?
Your Honor, today's date comes up for an examination. At this time, people are unable to proceed as to count one and would ask that count two be remanded to district court.
We need to dismiss.
I would move to dismiss count one.
People being unable to proceed on count one. That charge is dismissed. I'll continue to defendant's not guilty plea as to count two. Set this matter for pre-trial. Report Judge Barr on
June 18th.
And you're
June 18th, 2025, 10 a.m. Report Judge Barr.
if I may address bond.
You may.
Your Honor, the serious felony is dismissed in this case. This is actually the second time this matter has been set for a preliminary exam, and complaining witness has failed to show twice. He has another matter set with her tomorrow that's set for final settlement. Based on the trajectory, I'm assuming she's not going to show tomorrow. I'm asking for a reduction in bond. He's got $100 bond in that case. It's actually at 1,010%. I'm asking for something similar to that if it's a 1,010%.
Bless you. Response.
Your Honor, at this time, I'm going to object to modification of bond. This case is set again for guilty for the first exam, and then while he failed to appear, he did pick up bond violations with the same victim. So at this time, I'm going to object, and I believe it's something that did get addressed in the pretrial on.
You're right, Your Honor. Regarding that, I'm a part of that other matter. Mr. Johnson did turn himself in.
But he had 2 bond violations.
The allegations are regarding a location over on MacArthur Boulevard. We would not be objecting to anything regarding a tether where he would not be able to go near MacArthur Boulevard.
What I'm indicating is that when he was released on this case, he had 2 bond violations. So he seemingly can't follow direction as to what he's supposed to do and not do. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Beautiful day, Your Honor. Robert Ellman with and on behalf of Mr. Phillips, who's approaching. Mr. Phillips, could you please state your name for the record?
William Phillips. Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, if people are unable to proceed as to count 1, I would ask that count 2 be remanded.
You're moving to dismiss count 1?
Yes, Your Honor.
People being unable to proceed on count 1, that matter, that case is, or that charge is dismissed. I'll continue to defend its not guilty plea as to count 2. Set this matter for pretrial before Judge Barr on June 18, 2025, 10 a.m.
Your Honor, may I address bond?
He's out.
Correct. There was a
change.
There is a no contact order between the complaining witness and my client, which, as you know, previously she did provide me with a letter requesting contact. I know she's shared the same sentiment with the victim's advocate. She's also due to have their child on the 15th of June, Your Honor. So I would be asking for a change in that bond so that he can have contact and also allow him to be present for the birth of his child.
Your Honor, according to my notes, we haven't had any contact regarding her wanting consensual contact. The last contact we had with her, she confirmed it was her on the phone and then hung up and then didn't mention anything about contact. So we don't have any knowledge as to whether she'd want contact from our office.
Keep playing games every other day. Yeah, and it's like that.
It's what?
It's not. I know it's not. It's like
It's okay. Just let it go. Because if she's not here to say anything, he's not going to change his mind. You're just going to make yourself
Anything else, Mr. Elman?
No, Your Honor. Thank you. I just, again, that he would like to be present for the birth of his child.
I understand that, but unless we've heard, and I understand the letter, but I have not heard from her, as I recall it.
Okay.
So your motion for bond modification is denied. Bond will continue with its conditions.
And Your Honor, you said that the case is moving in front of Judge Barr. Did I hear that correctly?
Yes.
Okay. So any emergency bond motion would be in front of him at that time.
I don't know how he handles that, so go for it.
All right. Thank you, Your Honor. Good to see you.
Thank you.
A lot of important meetings on this.
Is that right? All right, we're ready on Gatlin. Right.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Ben Denowitz on behalf of Mr. Gatlin, who stands to my right. You state your name for the record, sir.
My name is Montel Gatlin.
Thank you. All right. Date and time set. Oh, yes.
Hey, John, before we proceed, I would like to just take accountability for what I've done. I would like to plead guilty to.
Hold on.
No.
Mr. Gatlin. No. Hold on a second. Okay, hold on. There's a process to it, okay? And so I hear what you're saying. You're not discounting it, but this would not be the place to do it, to do that right now. The question would be today, given what you kind of just said,
as to whether or not you want to have this preliminary examination. I would like to hold it, and I would like the court to hear me out. That's it. So you want to hold your preliminary examination? Yes, I would like to hold. Okay. Did you want to speak further with your counsel, given what you just said? And I would not like to speak further with my counsel. I feel like my counsel is what? Who he is. Okay. All right. Okay. I just want to make sure, and I'm doing this because I want to make sure things are fair for you, that you understand this isn't the point at which you would testify, typically. You understand that? Yes. Yes. Okay, that's what I'm trying to. So, here's the thing, Mr. Cameron. You said something to me, or said something out loud, stopped you, right? Yes. Then when I asked whether or not you wanted to have your preliminary examination, you then stated that you want to be heard. Yes. Okay. This proceeding, the preliminary examination, not saying it hasn't happened before, but this particular proceeding is not one where you would typically be testifying or saying things to the court. I would love to if you would give me a chance. Okay, well, let me do this, okay? Because again, I'm not disputing anything that you may want to do. I just have to make sure that you're not doing something that may jeopardize your rights, okay? So what? Just bear with me. I got to do my job, right? Okay. All right. So I'm hearing you. I think what I'm going to do is I'm going to pass the matter. I'm going to let you just briefly talk with your attorney and maybe the chief deputy of the public defender's office so that process-wise you understand it and understand what typically will happen at this proceeding and what won't happen, or what typically happens at this proceeding and also what typically does not happen. Okay? And I think you may be asking to do something that typically does not happen. And I just want you to be clear on that. Okay? I'm just trying to plead to all. Stop. Hold on. I hear you. If that's what you want to do, there's a way maybe to go about doing that. Okay? I don't think they're going to help me. Well, hold on. Stan, I hear you, okay? I'm trying to say it in a way. Here's what I'm going to do. I'm going to pass the matter. We'll find Mr. Brown. I'm going to have you talk to Mr. Brown, all right, with the PD's office, just to make sure you're clear on everything. Because I have to make sure that your rights are protected, okay? So we're going to do it that way. We're going to do it my way, that way, all right? That may mean you might come back up and we might be in the same boat, but I just have to make sure. Okay? Fair enough? Okay. So let's take him back.
Your Honor, real quick. Okay. Fine.
Take him back. Counsel approach, please.
Defender Ben Denowith on behalf of Mr. Gatlin, who is entering the courtroom now. Mr. Gatlin, would you state your name for the record, please?
Montel Gatlin.
Your Honor, at this time, the defense will refer Mr. Gatlin to the Forensic Center for competency. On both cases, I will email the form to the clerk of the court later today.
All right, very good.
Mr. Simpson, what's going on here?
I'm sorry? Well, they've asked for a forensic evaluation. There's not, well, just Gatlin, just hold on a minute. I can't when it's requested by council, there's really not a lot I can do except to do the referral. Okay.
A forensics on what?
Likely for competency and criminal responsibility.
I'm just saying, what is their reason for trying to even do this just because I was trying to say something?
Well,
What's their reason?
no. I don't. Okay, so I'm not privy by design to all of the conversation that you have with council. You have conversations with council.
And still state what I wanted to state on record.
And I'm gonna tell you something, Mr. Gatlin. That would. I just hold on a second. I don't know that would not only be a wise decision for you to come out and start stating stuff, but would also make me a bit concerned as to whether or not you understand the nature and objects of the proceedings. That is why I stopped it where I did the first time. And you're still in, and you're still in the same spot. And so your counsel has come out, they've asked for that. I'm gonna proceed to their request because they've made the request. So set a competency hearing date for
September 9th.
September 9th, 2025, 9 a.m.
Mr.
Simpson, go ahead. Go ahead.
So you telling me they pushing my next court date all the way to September just because I wanted to come in here and take accountability?
No, that I don't. No. I don't think you should look at it that way because the two aren't necessarily connected that way. They're not trying to push your case. The problem, Mr. Gatlin, is you're trying to do things that may not be in your best interest.
It's in my best interest.
No, it is not. That is why that is why I stopped the proceedings when I did. It was clear to me that what you were trying to do was not part of the process and may very well be against your interest to just
take accountability.
It's clear you don't understand how this works.
I'm being charged with these charges, and I was clearly just trying to take accountability for my charges.
And accountability can happen, but it doesn't mean that you load yourself up with everything that's there, which is what you were trying to do. And hold on, hold on. After, when we had Mr. Brown up there and I talked to Mr. Brown and Mr. Childers, Denowith, it's clear that there's an offer of some type.
I don't want to offer.
There's part of the problem. You're trying to, I'm done. Because you're not listening to it. You're just deciding you want to do something your way. I'm trying to explain to you why I'm doing it this way. I'm done. Bond continued.
Hello, everyone.
9-4, the state of Ohio versus Jerry Johnson. Mr. Johnson is before the court with his counsel, Mr. Gibbs. Ms. Belknap is here. My docket says Howard, and I do that a lot. And look at this. It doesn't look like Ms. Belknap's here on behalf of the CSEA. Mr. Gibbs, does your client wish to have a hearing on these allegations?
In discussion, Your Honor, it's my understanding that he wishes to admit to the allegations of violation.
Mr. Johnson, you understand that you're entitled to have a hearing, and you wish to waive that hearing and admit to the violation. Okay, the court's gonna find that you have violated the terms of your community control. Is this a merger?
Yes.
You're proceeding on count?
Count 2.
Mr. Johnson, Mr. Gibbs, is there anything you'd like to say? I know where the state stands, so.
Yes, Your Honor. In discussions with my client, he's very remorseful. He recognizes that, just frankly put, he screwed up and has stated to me, frankly, repeatedly, he'd rather go hungry than not pay child support going forward. He has been filling the role of caretaker for his girlfriend's mother, who has some pretty severe health issues. That was corroborated by his girlfriend reaching out to me as well. He's very motivated and, again, would request the court to permit him to be released so that he could obtain gainful employment and make good on these obligations.
Do we have a jail time credit on this?
Your Honor, according to Officer Henry, the jail time credit is 53 days with 21 days on this violation.
Mr. Johnson, is there something you want to say?
Since I've been incarcerated this time, that's all I do is think. I did write you a letter, I don't know if you received it. And I thought myself to a migraine after migraine. It's not fun. And like I would go hungry and pay child support than not pay child support and eat. You won't see me back again, I promise. If it's $30,000, my number one goal is if you release me today, I will get a job and I'll keep in touch with my PO. And I can't do this anymore. I just want to pay it off as fast as I can get it paid off. I promise you, you will not see me again.
Mr. Johnson, do you have any idea how many times I hear that in a day?
Probably.
Honestly, you've had 5 years to get this taken care of. Is the arrearage, has there been any voluntary payments at all from Mr. Johnson?
The last voluntary payment was when he was before the court at the preliminary violation hearing. He paid $100 that day. There was no voluntary payments in the year of 2024 at all.
How is that possible? You just said that you'd rather go hungry and not eat than not pay your child support, but yet here you are, fed and well-nourished, and you haven't paid any child support. How much has he paid over the course of this supervision?
Since he's been on supervision in January of 2020, he paid $7,535.84.
I keep my word, I promise.
I'm sorry?
I'll give you my word, I promise.
You gave me your word 5 years ago. You didn't do it. I don't understand. How all of a sudden now this is a priority?
Y'all mean business. I do.
Sir, I've looked at your prior record. I reviewed it before I came on the bench. I meant business 5 years ago. This wasn't something that just was discretionary. I ordered you to do it, and you ignored it. Right? All right. The court is dealing with multiple offenses arising out of the same incident, and the court will find that the 2 counts are allied offenses of similar import. The state electing to proceed on count 1, you will only be sentenced on one of the counts. Count 2, correct?
Count 2.
Okay. Mr. Johnson, the court is going to find today that you are no longer amenable to community control in the prison as necessary to fulfill the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. The court's going to further find that this is not a technical violation of the terms of your community control. Since this is a child support case, I mean, obviously paying child support is the key component to this. So the court had previously reserved a 12-month sentence. The court is going to order you to serve a 10-month sentence in prison. You'll get credit for the 53 days you've already served. You're also subject to a discretionary period of post-release control. Upon your release from prison, the adult parole authority may supervise you for a period of up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. Is there something you want to say?
So you're sending me.
Is there something you want to say?
So you send me to prison?
I am.
You're saying.
You did not do what I ordered.
For how long?
10 months, minus the 53 days.
So what is gonna happen on probation in Indiana? I'm gonna be violated down there and go back?
I don't know anything, that's not my jurisdiction, so I don't know the answer to that. All right, there's a deputy standing by. You go with the deputy, please. All right, this is case number 24CR41764, the State of Ohio versus Samuel Brown. Mr. Brown is before the court with his counsel, Mr. Mulligan. Ms. Nicholson is here on behalf of the State of Ohio. Ms. Nicholson?
Your Honor, this is a Judge Peeler case. This was set for plea a couple of weeks ago. Mr. Mulligan had asked that it be continued out to allow his client to get his affairs in order. So we are here for a plea with an agreed sentence. The agreed sentence is a total of 24 months in prison, 12 months on all of the counts that he is pleading guilty to, as well as 12 months on a gun specification to run. Those will run consecutive for the 24 months. He has agreed that he will not request nor be granted judicial release during that time period. The state also dismissed the firearm forfeiture specifications in exchange for the defendant to agree to forfeit the following 3 specific firearms that are listed by serial number in the plea form. And additionally, the defendant is pleading guilty to a money forfeiture specification to counts 10 and 11.
All right, Mr. Mulligan, is all that accurate? It is. Okay, Mr. Brown, they're telling me you want to change your plea to guilty. Some of these charges are amended charges. Looks like 1, 3, and 5 are amended charges. 6, 10, and 11 are original charges, and there are certain specifications to some of the charges. Before we get to your change of plea, I need to go over some things with you. Okay, sir?
Yes, Your Honor.
How old are you?
21.
How far did you go in school?
I graduated high school.
You can read and write, okay?
Yes.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you, other than this recommendation to me that I sentence you according to what this says, which is basically 24 months in prison, no judicial release, forfeiture of the firearms, and forfeiture of the cash?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Mulligan?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take any medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document called a change of plea and entry. On page 3 of this document, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yeah.
And you believe you understand what it says?
Yes, sir.
The first count that you're pleading guilty to is aggravated possession of drugs as a felony of the 3rd degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that is a mandatory fine. Count 3 is aggravated trafficking in drugs, also a felony of the 3rd degree. That also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. And again, $5,000 of that fine is mandatory. Count 5 is one of trafficking in hashish. A felony of the 3rd degree also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. And again, $5,000 of that is a mandatory fine. Count 6 is possession of hashish. A felony of the 3rd degree also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that is also considered to be a mandatory fine. Count number 10 is trafficking in marijuana. A felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. That carries with it a firearm specification of 1 year in prison, which is mandatory and must be served prior to and before any other sentence is prior to and consecutive to any other sentence the court issues. Do you understand that?
Yes, sir.
All right. That also carries with it a specification for forfeiture of money in the sum of $7,421. And then finally, count 11 is the possession of marijuana as a felony of the 5th degree, and that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. And that also has the firearm specification with it of 1 year and a forfeiture specification for money of $7,421. Is it the state's position that these firearm specifications merge?
Yes, Your Honor. We're dealing with the same firearm, same.
Okay.
Yes.
Just wanted to make sure. Sometimes they stack.
No, yeah, they merge.
Okay.
That's our position.
So do you understand the maximum and mandatory penalties involved with all of these charges?
Yes, sir.
In addition to those maximum and mandatory penalties, you are also subject to a discretionary period of post-release control, which means upon your release from prison, the adult parole authority may supervise you for a period of up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you're presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the state to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they are required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
And you have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything else from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the state. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. Judge Peeler would also have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, Your Honor.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? There will not be a trial.
Yes, sir.
This is how you wish to proceed?
Yes.
All right, Ms. Nicholson.
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about August 21st of 2023, the defendant sold over the bulk amount of psilocybin and psilocin in the amount of 467.3 grams. That is a Schedule I substance. And that on August 31st of 2023, that the defendant sold, again, over the bulk amount of psilocybin and psilocin in the amount of 492.4 grams, also a Schedule I substance. That on January 4th, 2024, the defendant was arrested with hashish in the amount of 441.34 grams of Schedule I substance in his vehicle. He was there at that arrest with the intent to sell that solid hashish. And then a search warrant was conducted on his residence also on January 4th of 2024. And in his home was located marijuana with all of the tools necessary to sell that marijuana. There were also 3 firearms located in his home at the time of the search warrant, along with all of those drugs, as well as $7,421. The buys and the arrest all occurred in Warren County, and the search warrant was a part of his continuing course of conduct.
All right. Mr. Mulligan, anything on those facts?
No, Your Honor.
Mr. Brown, did you hear the statement that she read?
Yes, Your Honor.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, those rights we just discussed?
Yes, sir.
And what is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed, and the court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. It's my intention to proceed directly with sentencing right now. Ms. Nicholson, anything on behalf of the state?
Your Honor, nothing in addition to the agreed sentence. We would ask that the court sentence the defendant to 12 months on the counts to which he pled, 12 months on the firearm specification, for a total of 24 months in prison. We would ask for a $1,410 lab testing reimbursement to be ordered to the Warren County Drug Task Force, and that the court, based on the defendant's agreement to forfeit the 3 firearms mentioned in the plea form, that those be released to the Warren County Drug Task Force to be disposed of pursuant to law, and that the court order the forfeiture of the $7,421.
Do you have a jail time credit?
He has 0 days of jail time credit.
Mr. Mulligan?
Your Honor, first we would ask that the court impose the recommended sentence. This has been a learning experience for Mr. Brown. I honestly do not expect him to be back before another court based on what he has dealt with. He has shown the ability in the past to be employed, and I would anticipate that he would regain that employment once released.
Thank you, Mr.
Maybe
Brown.
not
Is there
with the same employer, but I expect he will have a job.
Okay. Mr. Brown, is there anything you'd like to say before I sentence you?
No, Your Honor.
Mr. Mulligan, do you have an affidavit of indigency?
I thought that we did, Your Honor.
Let me look, I have it up now, hang on 1 second.
Yeah, we filled one out.
Yeah, we did previously fill one out, and I believe it was filed as well.
Yeah.
But it was some time ago when that,
All right, let me go back on the docket and make sure.
I'm looking as well. I don't know that I see it filed.
Probably within around November
November?
or December.
I do not see an affidavit. I do not see, oh, wait a minute. No,
I don't see one in benchmark.
I don't see one, Mr. Mulligan.
I'd be disappointed if it was still in our office. I can inquire of my staff whether it was filled out, but I know that we physically filled it
Yeah,
out.
yeah, because I came in and filled it out.
Right.
I think it was around 5 p.m.
We can fill out the form again here, if the court would give us a minute or two.
Okay.
On hold.
Yeah.
Did you get lunch?
I'll make it. Deputy Cressup's here too.
Then I have other two.
So I don't have to worry about,
Chances are,
I don't have to worry about the food going to waste, right?
right.
As of today, Your Honor, he is, of course, not employed. He's reporting no assets and has debts on automobiles that would are significant, and he has about $15,000 in credit card debt. And he's filled out the form. I can notarize it.
Okay.
Thank you. Appreciate it.
All right, again, Mr. Brown, is there anything else you'd like to say?
No, Your Honor.
All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevance, seriousness, and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on count one, you're ordered to serve 12 months in prison. On count 3, 5, 6, 10, and 11, you were ordered to serve 12 months in prison on each of those counts, and each of those to be served concurrent with count 1. You're also on the count 10 firearm specification, ordered to serve 12 months in prison, and that is by law ordered to serve prior to and consecutive to the 12 months in count 1, which leaves a total sentence of 24 months in prison. The court is ordering the forfeiture of the firearms as listed in the plea agreement and the forfeiture of the $7,421. There's 0 days jail time credit as of today. The court having found the defendant indigent for the purpose of any fines, costs, or other financial sanctions, including the mandatory fine as outlined in the plea agreement. Now, you are also subject to a discretionary period of post-release control, which I spoke about a moment ago. Do you need me to go over that with you again?
No, Your Honor.
All right. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision if you're sentenced to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Nicholson, is there anything else?
I don't believe so,
Mr.
Your Honor.
Mulligan?
Thank you.
All right, at this time,
For sending it over, and I appreciate it, he appreciates it.
all right, at this time, you are remanded into the custody of the Warren County Sheriff for transport to the Department of Corrections. All right, thank you. Yeah, denied. He's not eligible. Yeah.